This person feels that, well, I could have gone in for 20 years, I'm only doing 5. So it's a win-win situation for everyone.
But is this supposed to be?
Sometimes in the interest of justice, that is what needs to happen. You know, just if you look at as a victim, I mean, somebody has been terribly stabbed and, you know, a whole lot, you know, the family is traumatized and they're going through that, and you have to, you know, these victims who have been brutally assaulted by an accused person, right, will have to face this person every single day in the courtroom, relive the whole scenario over and over again, right? And the person decides that, listen, I'm going to plead guilty to this for a reduction in sentence. I think in the interest of justice, you know, I'll take it, you know, to save the victim from going through that emotional and psychological trauma.
Again.
Yeah.
Okay. So has this always before? The Act came into existence 2022. Has it informally been in existence, or it was just 2022?
Well, I would say formally 2022, but before then there were some specific offenses that you could actually plead back in. I mean, mostly these financial crimes and things like that, right? But now it's extended to all offenses, with exception of murder. Really, you can't kill somebody and then go and say that, listen, I want to plead guilty to manslaughter. So give this. I mean, that is not the case. But you know, high treason and all those things are exempt from this plea bargain arrangements. Yeah.
But do we have a particular stage during the criminal trial that plea bargain can be introduced, or any time within the trial?
It's, you know, the beauty is any time, you know. I mean,
obviously before
conviction, but it works for both sides, isn't it? You know, it's a game of chess. You know? So if I think, listen, it's going well for me, I mean, I won't enter into plea bargain. I want to make sure that my client walks because he hasn't committed any offense. But if I think at some point something really terrible is going, my job as an officer of the court is to help and assist the court. So I might say to my client that, given this new, fresh evidence that has surfaced, I don't think we stand a chance. So do you know what? Let me salvage the situation for you. Let's enter a plea bargain and get a reduction in sentence, and then in no time you'll be out. Sometimes some of those clients will understand and they'll go for it. So from the discussion so far, the accused can propose, the prosecutor can also propose plea bargain. Normally,
but usually
the prosecutors don't. They will not, because they think they have a watertight case. And
so the prosecutor will not propose, like looking at their case, it's not strong enough. So
yeah, I'm a criminal defense lawyer. A prosecutor comes to me and tells us, listen, you know, let's go into a plea bargain or whatever. I'll say that you don't have a case.
Yeah. It's a chess game.
You don't have a case. But if you have a good case, why would you come to me? Ask for a plea bargain.
So that you don't waste that time in the court.
I mean, I think I have a good defense. Don't forget that in a criminal trial, it is the prosecution that will have to furnish you with what they have against you. And the law requires that even if they have an evidence or exhibit, a material that is adverse to their case, they still have to hand that over to you, right?
Yeah.
So if upon disclosures, and you realize from the disclosures that they don't really have a case.
So disclosure is when they bring everything out.
They bring everything out, what they have, what they are going to rely on. And even the ones that they're not going to rely on, they still have to give it to you. So long as it's in respect of that case, they have to give it to you. And you decide how you use it, right? But they will decide how they want to use theirs and tell their story. But of course, as a criminal defense lawyer, if I see a disclosure and I think that there's nothing in it, I'll go to trial. I will not plea bargain. But if I see a disclosure and I think, wow, this is going to be tough, it's going to be a mountain for me, I will advise my client, listen, there's another option for us. Let's enter into a plea bargain, all right? And I'll advise the client as to why we need to. I'll give them the pros and cons, what awaits us if we go to trial and we get convicted. This is what you stand to get in sentencing. But if we go for plea bargain and it works for us, this is what you're going to get. Sometimes the clients will weigh the two and they decide, yes, I want to take it, or no, I want to go to trial. So
let's say you've agreed, the judge has accepted it, the accused have been sentenced to 5 years. 2 years later, the accused comes back and says, no, I'm changing my mind. I was never in agreement. Is that possible?
Well, it cannot be possible. It cannot be possible because a plea bargain agreement is like a contract. It's like a terms of settlement, yes. Right? Where you, the accused person,
I've changed my mind.
You signed. It's too late. I mean, you signed. You signed, and your lawyer signed. All parties have signed.
And maybe the judge will ask you,
do you still want to go through? And what happens is that you then will mount the box again, and they'll read out the charges to you, and then you plead guilty to them. So in effect, you have pleaded guilty simpliciter. So you can't come back and say that I changed my mind for what?
Well, maybe I was coerced. I didn't understand.
Well, if there's evidence of coercion, then you might have a case. The court, I mean, the higher up courts might set it aside, right? But unless there is one, and I can't see how your own lawyer will coerce you to plead guilty to something that you didn't do. That in itself will raise ethical issues, you know, so that hardly ever happens.
Is the victim himself or herself ever involved in plea bargain?
No. No. Sometimes, I mean, all the cases that I've done here, cases that I really have done here, I think it was only in defilement, in some of those defilement cases and some rape cases where the victims really have written like letters, but it's not our practice. You know, like other places, you have victim impact statements, and all that will be read before you are actually sentenced, and the court also looks to see whether you're remorseful and all that. But here your plea mitigation is normally done by your lawyer, and will tell the court that, you know, my client is very sorry, regretted and all that, and the court will take that into consideration in sentencing. But many a times the accused person themselves doesn't speak. They don't say anything.
But it's possible the prosecution will talk to them, let them understand what is going on.
You mean the accused person?
So the prosecution will tell the victim that there's a possibility of plea bargaining. That's what they intend to do. At least let the victim understand.
Yeah, I think you know, I did my pupillage at the Attorney General, and you know, they do that. I mean, the prosecution works closely with the victims or the complainants, and they keep them informed of every single stage of the prosecution. So yes, they do.
Will you say plea bargain is buying your way out of a crime?
No, I don't think so. I think plea bargain is there to help to minimize miscarriage of justice.
How?
Yeah, because you see, sometimes the person haven't done anything wrong, right? And the prosecution wanted to sentence the person. I mean, when I say haven't done anything wrong, sometimes somebody have done something, but they're not, you know, the person cannot be deemed to have been committed the offense. There are ingredients, right? There are certain bits of the ingredients missing. And when it comes to criminal law,
so give us some example.
Everything has to be right. Okay. Now let's say that. What can I say? You provided ammunition for. I'm not gonna say ammunition, like instrument for somebody, and they went to beat somebody up, and you know that what you are giving to the person, they will use it against Mr. A, but you did anyway, okay? And for some reason, you rather have been charged with assault. You have been charged with assault, okay? And the person who did it is probably at large, right? And you know that that charge will not hold against me, because at worst, what I did was abetment. I facilitated the assault. But the person has been charged with assault. And you're going to court to say that you provided an instrument and you all worked together, you did this. And once there's no second person to be charged with conspiracy, a charge of conspiracy will not hold against me, right? Even a charge of assault will still not hold against me, right? But I know I've done something wrong, yeah, and I want to put my hand up. But I tell her, listen, maybe I'll plead guilty to abetment, yeah. But instead of giving me the maximum,
like the
sentence like this one, maybe give me some short sentence or whatever. Let me be free. I don't want this hanging over my neck. Yeah, something like that will happen, because if you sentence the person for assault, that's a miscarriage of justice. The person will go on appeal, right? And again, you're gonna waste cost time.
But is it fair to the victim's family, especially when the victim is murdered or when the victim is incapacitated due to the accused actions? Would it be fair to the victims? Will plea bargain be fair to the victim's family?
Sometimes yes, and sometimes to maybe no. Let me play devil's advocate here. The yes is in the sense that you are guaranteed conviction, right? You are guaranteed conviction. But are we saying that is it the length of sentence justifies the victim's suffering? The answer is no.
Why not?
Well, if you sentence the person to 10 years in prison.
Because if you've crippled me and you're going to prison for 20 years, you might be going to prison for 2 years.
If you send somebody to prison for 20 years, will not help the victim who is in a wheelchair.
But at least it will appease.
Well, you see, sometimes this retribution doesn't really work. Yeah, retribution doesn't work.
But what about punishing the offender so that it doesn't happen again?
Yeah, I mean, you have to also look at the interests of the accused person.
The interest?
Of course, yeah. The law is clear, right? You have to balance the interests of the accused person as well as the victim, as well as the citizens, right? So you cannot lock the accused person and throw the keys out. He's also a citizen of this nation, and his welfare is also crucially important. You have to look at that. So sometimes, plea bargain ensures that the accused person is punished for what he has done, and is going to either prison or whatever that the law deems fit, and it brings some sort of closure to the victim. Sometimes too, it is not, but where the judge have the final say, the judge ensures that in any plea bargain, it must reflect the seriousness of the offense and the deserved punishment.
What if plea bargain is done and the public deem it not fair?
The public deems everything not fair.
That's all fair. Because
we're not here for the opinion of the public. The judge will have to balance have to balance the interests.
But the whole idea is that everything is being done in the name and for the people. That says the Constitution. So if the people are thinking that this is not fair.
Yeah, but the law is not about public opinion. You know, other than that, we don't need a courts. You just have to put them on the street, and you get fair street justice. But that is not what the law is. Yeah, the judges who carry the big wigs and the white wigs means that they have wisdom, and they've been vested with the authority to balance everything, and they do it well. Do it well.
They do.
Because if they don't, you go up to the three musketeers up there, and if you're not happy there, you go up again. I mean, the chain of command is very clear. But in my view, we rather need to use plea bargain effectively.
Okay.
Effectively. And I've done cases where, you know, I've said to them, I don't want to waste the cost time. We want to plead guilty to a lesser offense to get a lesser punishment. And they said, no, the section we've charged you with doesn't provide that sort of punishment. So, you know, we can't do that. So if you're going to plea bargain, we'll take the minimum, 10 years. Why would I go to prison for 10 years? I mean, for me to go to prison for 10 years, I'd rather go to full trial, because at least I have another chance of an appeal. Are you with me? Mm-hmm. But if I accept 10 years, I'm doomed for 10 years.
Maybe it will have been life imprisonment.
Life in prison unless I kill somebody.
Kill someone, which is all.
Yeah. But we're talking certain offenses where sometimes the prosecution are not flexible. Right? They're not flexible. Mm-hmm. They want straight jacket. If it's a plea bag, you know, tell, okay, plea bag, we'll give them minimum 10 years. But sometimes you just have to change the charge, because there are three ways, right? You can plea bargain on the charge, sentencing, and, you know, and non-prosecutorial withdrawal. That is clearly stated in the act. So why can't you explore that if there is another alternative offense which has to be lesser, and they're not wasting the cost time? A trial can go on for years. I've done one trial that went on. In fact, I inherited it, right? Criminal offense. 11 years. It went on for 11 years. And you ask yourself, 11 years, when the case started, where were you? What were you doing?
And the accused was? In the end, they were given, I think, very short sentences, because most of the time was in prison. So they
were granted bail.
Okay.
They were granted bail, but you can see that during the course of the trial, you know, they've lost the elements. Everything's gone. I can't remember this. I can't remember that. You know, judges have changed hands. So, I mean, there's been about 4 or 5 different judges that are in that span, and the final judge really ended it. And I think the maximum one got was about, I think, 2 years or something like that.
So at least it helps with the court in respect to cases, laws, and
the fast track,
and even the state in respect of resources.
You know, if we use plea bargain very effectively, and we use it well, it will declot the courts. At the moment, the courts are inundated with cases, and if you go to court tomorrow, and I'm pretty sure that you won't get any date in December or even January if you're fortunate. You'll be looking at February, right? Mm-hmm. So if we can take some of these things, some of these like cases out by way of plea bargain, especially those non-custodial ones. Or, I mean, there's only a few that are non-custodial, you know. But the ones that are not major or very serious, and we can resolve them that way, it will free up the courts for the judges to have time and concentrate and do other pressing ones. But we need to be able to use it effectively. Okay.
Any success stories when it comes to plea bargain?
Well, I've had a few.
Give us one.
But I think there's one that I went all the way to. We're almost getting to the end of the case, and I realized, and listen, you know, maybe if I plea bargain, and I prepared my client, you know, so listen, we are looking at between 10 to 15, right? And we are in the hands of the judge. So let's see if you can plea bargain. If you get 5, I think that's cool, right? And in the end, I think we got 4. It was out like in 3. So that was okay.
It was.
Yeah.
That is a success story. Yeah. Does it fit into the idea of restorative justice?
No, I don't think so. I don't think so. Because, to restore a person, one, the person must know that what they've done is wrong. Mm-hmm. And the person must, avail themselves to actually change, right? But I don't think plea bargain is a way of ensuring that. I think that we have to look at our sentencing policies, because the majority, if you look at Act 29, and our sentencing policies are all tend to be what do you call it, an eye for an eye, that type of thing. Are you with me? Right? And we don't need that.
We don't?
We don't need that. Listen, for years, since Act 29 came into effect in 1960, what is the crime rate in Ghana today? And it's getting even worse. So it means that those retribution isn't working. It's not working. We need reformative. We need reformative, sentences. I believe giving people shorter sentences, and while they are there, they need to be given proper education, training, right, and tools to work.
That I do,
right,
yeah.
And that will help more. Now, you see, when you send somebody to prison for 10, 20 years, psychologically, you prepare the person to say that he's not among the living, right? And so, when he goes in, what is he going to do? He's not going to help. He's not going to be productive. He'll be dead to be mischievous.
But do you think if we didn't have that, maybe the current crime would have been worse? Because someone was using the example of an eye for an eye. So you kill someone, you should be killed. No life sentence.
But the thing is, once you kill that person, doesn't mean that somebody else will not do it.
But it's preventive. It helps so that someone else will not go and kill. So that was lawyer Frimpong's argument. Right.
Now, listen. I did advanced criminal law when I was in the UK, and I looked at all that. Deterrence. Because our sentences are more of deterrence, retribution, and all that. How do you deter somebody?
Everyone is afraid to die, so I'm not coming and kill you, so I'll die.
The person has not been caught. That is why I think it's deterrence. Right? How do you know?
But all things being equal, he said, I know that if I kill, I'll be killed.
Yeah.
And I don't want to be killed.
But the person, no. When somebody...
Or we'll do like what the guy did, kill the family of 6 and went to kill himself.
And then kill himself. What should the prophet... what do we get out of it? I think we need more. We have to look at the fundamentals. What is causing people to commit crime? When you go to Insolent prison, go to Ankara prison, go to all the prisons that we have, the male prisons that we have here in Ghana, the average age is between 21 and 40. And these are productive years, and they are all languishing in what? In prisons. Insolent prison is taking over 7,000. It wasn't built for that. We have that many people there. These are working age, languishing in there. What is it? We have to look at what causes people to get into life of crime, and trying to resolve that, trying to do something. With this system of you are there and I'm here, isn't helping us. It's not helping us at all. Sometimes I'm in a courtroom and I cry, seeing a young man going to prison for. And this thing as well, I'm not because I'm a criminal practitioner, so I think I'm advocating for like offenders or not. That's not the case. I did one case, right? A schoolboy with his friend, and they were playing pranks. Okay, and then he picked his scissors from his pencil case, and the friend was holding the phone, and they did this, right? And the friend panicked, and then they dropped the phone. He picked the phone, and the friend went to report to the parents, and then the parents went to the police, and reported what has happened. The police arrested this guy and charged the boy with robbery. With robbery.
It fits it. Okay, and the menstrual, but all things will fit it.
And he came to court, and he doesn't really, unrepresented. He doesn't understand what was going on. And when they asked him that, this is what you say you have done, and you see the interpreters also doesn't interpret it to show the seriousness of the offense. And he said, "Oh, yeah, the scissors was in my bag. I took it, and I didn't hit it with it. Did you take his phone? Yes, I took his phone. That was it. 10 years. What?
All the elements are met. So robbery.
The elements isn't met.
Stealing. There's a weapon. He did steal. He had the intention to steal.
They're different, and maybe another time.
Maybe because you are looking at this from the defense angle, you are thinking that maybe he was joking. Maybe he wasn't joking. He indeed wanted to take the phone.
They're all school friends. They're all school boys, mates. And they were friends. And even the victim he couldn't understand that the guy is going to prison for 10 years. When he was told he was going to prison for 10 years, he was shocked. He said, "But what have I done?" But that is it. Guilty simplicity, right? And sometimes certain offenses happens, and you don't have to charge them with robbery. For example, I've come to steal your mug, right? And I've taken the mug. On my way out, you realize that your mug is gone. And then you started shouting at me, chasing after me. I was running, right? And I turned around, I did this as I was going to hit you. You let go, and I run, and I've been arrested. Is it robbery?
No. Because the force wasn't used when you were stealing.
Thank you, but they'll charge you with robbery.
So that's why you come in and you help your client.
No, but what if I'm not there? What if I'm not there? You see, the charging officers have to understand.
I think we should look at the prosecutors again.
That's right, and that's it. So somehow, the plea bargain is like a buffer to help for me to get a much lesser sentence. If I don't have
for a minute, I forgot you were doing plea bargain.
Well, that's it. If I don't.
So if I'm an accused and I hear of plea bargain, what should come to mind, and what should I be thinking, and what should I be asking? The questions I should be asking.
Yeah, I think you should be asking, what does it entail in respect of your case? If I was to plead guilty, what will be the implication, right? And what will happen? And you need to understand. Also, bear in mind that once you enter plea bargain and you plead guilty, you become a convict.
Yeah.
Right? An ex-convict when you finish serving your sentence. And this stigma lives with you for life. So, in effect, you'll be sentenced twice, isn't it?
No.
You suffer the physical. You suffer the physical incarceration, and then you have to live with the mental incarceration. That is a stigma for life. But what is important is we help people not to enter into the world of crime.
To the public, what will you tell them? Because frankly speaking, most people think justice is being sold.
No. To the public, what I would say is that plea bargain is a means of, one, saving the victims from going through trauma, living and reliving their ordeal, and also to the accused persons, knowing very well that they committed the offense, not to waste the cost time, put your hand up early and get a reduction in sentence. And that's what it is. But it's not a
Mm-hmm.
a justice for sale. Far from it.
But how can we make it transparent and trustworthy? Can the court system, can the judiciary do anything to make it plea bargaining trustworthy?
I think many a times some prosecutors tend to use as a confetti anything they say, well, maybe you can go plea bargain. No, the option is there. It doesn't mean you have to take it. If the evidence is not against you, if there's no evidence against you, why should you enter into a plea bargain? Many a times, these accused person doesn't know their rights. Majority of them, especially when you go to some of these district courts and circuit courts, they're all represented, right? But then you look and see that there's no evidence against them, and then they'll be coerced into going to taking a plea bargain and incriminating themselves. That is wrong. And when I see that, I speak out against it. That is wrong. They should be given the full information, and the prosecutors themselves knows that they don't have a case. Mm-hmm. They should not persecute them. Mm-hmm. They are there to prosecute. Mm-hmm. And it means that if there is something mm-hmm. that goes to the benefit of the accused person, you must let them know. Mm-hmm. You must let them know, because your job is to present the facts and let the judge make a finding, right? But sometimes prosecutors, I say that they take it like a World Cup. At all costs, they want conviction. Mm-hmm. Even if the facts are not there, they still want to convict you. And when that happens, it becomes persecution, not prosecution.
Yeah. Yeah. So looking at the prosecution again, you hear of clients, people going, they are being charged, they go and then they tell them, should I say lies? That we have this, we had this, we have this, we have this. So all you have to say in court is that you did it. And you say you did it, it was, they were shutting the whole thing for you. And I heard a story like that and I was shocked. So the person said guilty. They sentenced a guy to 16, 17 years. And the guy was like, yes, I'm a prosecutor. Prosecutor said, may I guilty? I'll go scot-free. And they just said, what? And that was the first time I heard that.
It happens every day. I've faced this. I've seen a lot of it. And I'll say this in your program, mm-hmm. that if you are a prosecutor watching this, it's not the prosecutors that do that. It is the investigators yes. that, because they've been arrested and they're coming from police station, they don't want to be carrying them to the court all the time, because sometimes too, the investigators have to pay the transport themselves to bring them. There are no police cars to bring these accused persons to court, and the prosecutors have to use their own money to bring them to court. So some of them take the easy way out and tell them, when you go, just plead guilty and they'll give you a fine, when they know very well that they are facing an indictable offense. And when they plead guilty, it's a prison. So they bring it there, you plead guilty, and they sentence you, and now it's it. You are going. So by the time you say that, oh, and yes, I'm not catching him, it's too late. It's too late. But if you do that as an investigator, then what you've done is so evil that you don't deserve the work you are doing, and you don't deserve your salary. Because
the idea is to find out the truth, not necessarily incarcerate people. And so it's about the truth.
It happens. There's a lot of people in prison that are there because they put their trust in investigators to advise them, because they don't have lawyers. And they believe that they are people in authority to tell them what really will happen, and they get them to go there and hang themselves.
So in one sentence, will you say plea bargaining strengthens or weakens our justice system?
Our justice system is growing, and I think plea bargaining is part of the growth. And it's a good one. It's a good thing. I'm happy. I am really happy that we can all use it. But my issue is we have to use it very, very effectively.
So let's look at what is currently happening in Ghana, where accused person, the charges of an accused person, the charges are dropped, and the person is used as a witness vis-a-vis a plea bargain. Mm-hmm. So what's the difference? And with that angle, do you think justice is being served?
You see, I think that really facilitates our justice system. and it helps to reduce, like I said, miscarriage of justice. Now, many a times people are arrested, right, and they are charged as a group, but when you look at the involvement of individuals, you realize that there are people who know the facts, but they haven't committed any offense. Their involvement really is not criminal, but yet they've been included. And a smart prosecutor will look at that and decide that, no, let me use this person as my witness because he knows what's going on. He can provide information to the court to convince the court of our theory and our story. Okay? And so they will drop the charges against the person and then make them prosecution witness, and that will help to facilitate justice. Okay? But if you don't, you know your case is going to fail against that person anyway. And if your case fails against that person and the evidence you have is not so strong, right, then it means that all the others that committed the offense will go because you cannot prove beyond reasonable what? Doubt. So it is good that when upon perusing the case and examining them very carefully, if you see that there is a suspect who maybe is being investigated for a particular offense, but that offense will not hold against that person, but they have in-depth information to assist you to prosecute the others, then it's wise for you to
so why drop all charges? Why don't you maybe decrease the...
Okay, what it is this in criminal practice, in criminal law, a co-accused cannot testify against another co-accused. Are you with me?
Yeah.
So whatever you say can only be used against you and not against your co-accused. So if I have in-depth knowledge, yet you've charged me with an offense, and you want me to be a witness for you, how can it be? Are you with me? Because I'm also a co-accused. Unless you charge me separately
with a difference
and have me convicted.
Oh, okay,
and then you want to bring me back to use me as your witness.
But then again, why will
I do that when I've been? So are you with me? So sometimes, and then again, once the person is a convict and you bring that as a witness, what's it going to be the weight of evidence? Right. So it's best to withdraw the charges.
Then it means for prosecutions to withdraw the charges, and they really do have a case. Like, as in the person who is bringing the accused person, who is now going to be their witness, has a very strong...
Well, it might even end up being their star witness.
But what if at the end of the day, all that, and then really nothing much?
Well, I mean, it's not...
And the person walks free like that?
Well, some have to go free. What it is that the case officer, the prosecutor who is actually handling the case, would assess everything, look at all the evidence, do their maps, work everything out, and see where their case theory goes. And so for them to withdraw a charge and use a person as a prosecution witness, they are very confident that they will get conviction, because maybe in their case, there's a hole at some point, and they believe that witness will fill that hole for them, right? And if if that witness comes through for them, then hooray. But sometimes the danger is you withdraw the charges and the person goes on there and becomes a hostile witness. Then what happens to you? Yeah.
They turn against you.
So,
but can there be an agreement where such may not happen? So I have an agreement with you that you're going to be my star with them, blah blah. But if you turn a hostile witness, if you do not give me the information I need, if you don't give me the evidence you said you give me, I'll prosecute you again.
No, but what is that?
Double jeopardy.
You're holding a gun against me. That's duress. That'll be on the duress, and I don't think that'll work for you, because me as a criminal defense lawyer, I'll use it against you in court. Yeah. I'll tell you. Well, you've been told that if you don't say those things, that's what they will do to you. Is that correct? And the person says yes, well, your case is full. Yeah. But no, I don't think they do that. And sometimes I know the prosecutions don't pressure you. They tell you that, listen.
That's the AG, the police prosecution.
Well, that one is a different thing.
Different ballgame.
That one is a different ballgame altogether, you know. But, you know, the AG, they lay the cards on the table for you and everything else. And many a times, once the person accepts, they follow through. Yeah. But you see, the AG doesn't persecute. They prosecute. Yeah. And I've done cases. I mean, I've done a lot of cases with attorneys from the AG's office. And, you know, even things that will go in your favor, if they have to disclose and they have in their possession, they'll disclose it. But they are very professional when it comes to presenting their case and, you know, prosecuting their case, cross-examination. Very, very professional. And it helps. It brings out the beauty of the profession. But when you go to the other side, it's a different thing.
And I'm told that sometimes when they are bringing the evidence, they will hide the one they know or they think will help your case. They hide it under the whole lump of evidence.
But there is it. But whenever an AG attorney gives you a bundle, don't take it on the face value. Put a light on it and sit down and take one page after the other and read all. Because of course I'll do the same, you know. If I think there's something, I mean, I'll hide it somewhere for you to find out. That's what we all went to law school for.
No.
Yeah, no, but I think when you have a documentary evidence, it's incumbent upon every lawyer to peruse them.
Yeah.
And make sure that, because without it, you don't have a story to tell. And so you do that. Yeah, but they don't deliberately hide things. No, they don't do that. What I found with the AG is, if you take their bundle and you read through, you can follow through what the theory is from the bundle that they've given you. Yeah. So you also prepare accordingly. Yeah. Yeah. So it's not that bad. Though, of course, when we are all on our feet, it tends to argue strongly, you know, but it's a good system. And they don't coerce you. They will not force you to. So
I think that's one area of law I've really not tried to go into, because I don't know, I feel as if you're not careful, you'll be drawn in too much. Criminal law. How has it been?
Right. You know, criminal practice is an act. Criminal practice is an act. You know, sometimes...
You're a reverend?
Yes, I am, yeah. I mean, I preach on a Sunday, and on Monday I'm in a courtroom fighting, yeah.
and your followers will say you are fighting for criminals.
I don't fight for no criminal. No one is born a criminal. I fight for people who have been accused of offense that they believe they haven't committed. And it is not for them to prove anything. It's for the state to prove their guilt. And my job is to help them to make sure that they get proper representation as what the Constitution requires. So I'm doing my job. I'm fulfilling my constitutional duty.
So what happens if you know indeed the person has committed an offense?
You see, this is it's good that you asked this question, and I need to educate our viewers. Right. First, you are an officer of the court before your client. Mm-hmm. So my duty is to the court first before my client. So if my client tells me that he committed the offense, I can't come to court and cross-examine witnesses trying to prove that my client did not do it when he's told me he did it. So what I'm doing is I'm misleading the court. Mm-hmm. If I do that, then I am misleading what? The court. Yeah. So if you tell me you did it, then I'll tell you that, listen, we need to go in and plead guilty to it, and let me mitigate for a lesser sentence or punishment. And that is what I'm saying, that this plea bargain comes handy, because when you say that to me, then I'm advising for us to go for plea bargain to get you a lesser sentence or a lesser punishment. But I cannot come to court and deceive the court by pretending as if you never did it and to argue strongly that you did not do it. And if I'm pushed, I'll have to give you back your brief to go somewhere else because I'll be I'm compromised.
And so that's what usually happens when. So someone will tell you that when a lawyer tells a judge, my lady, my lord, I don't think I can continue with this case. That means that the person is guilty. In a way, subtly, you are telling the judge the person is guilty.
But you see, I mean, the behavior of a lawyer will give an indication to the prosecution that there's something untoward. But because I would say that I cannot continue with the case because there's a conflict. There's a conflict of interest here. And for that reason, I can't. I don't even have to tell the court. I can just file, what do you call it? To represent, to withdraw my representation, to give the accused person a fair chance of giving a brief to a new lawyer with fresh eyes. But you cannot tell me you've committed the offense and I come to court and argue otherwise. I can't.
There are also, of clients too who have, in quotes, fired their lawyers right there in court.
Oh, but
open court.
I've suffered that.
You have?
Yeah, I was sat in a courtroom and when we're doing the Cardinia case, I was representing 3 of the accused persons. There were 4 of them, and I was representing 3 of the accused persons. And the first accused person, sacked me in the courtroom.
Open court.
In open court, told the judge that he sacked me. He doesn't want me anymore. Why? Because the trial have just started and he wanted me to apply for bail, and I said no, I cannot apply for bail now because trial have started and the prosecution are definitely going to oppose. Right, let's go through the trial. After the first half, when the prosecution finishes the case, I'll file a submission of no case, and at that point I can even make an application then. But not when the trial is ongoing. We don't stand a chance. And when I advised him, he felt that he could get somebody else to get him a bail. So he sacked me, and in open court. And when it didn't work for him, he came back again. So he came back again, and
it took him up.
He came back to re-engage me again.
And you did?
I did, and he sacked me again the second time.
I hope you got your money. I hope at least you get your money. All right, so senior, everything we've discussed so far, I'm giving you 2 minutes, 2-3 minutes. Summarize everything in 3 for me.
In 3?
Yes.
Right.
That's it.
Okay.
That's
how will I say a plea back? Okay. Actually, sometimes I struggle, but the woman said, "Sisiano and Ghana say ye bo kwadu bi na say bio wonim say kwadu na dia bo no ewom ebia adekodi a yesi wakoye no bone kwan yesi waye no ogitu say bia waye na ompese obetwi nsem bebre ama wasi court no time na de bia we di court akone abanade obetimi ene wetimi ne lawyer na so be kasa ka lawyer so say ebia me say meji memfum so etum na mum asotwe no yente so mame emra wo hosa chese aban betimi ayede aji wasem na tum na waji asotwe atum na chese o mate asotwe no so enti eno na e friend no Ghana say friend no plea bag no enti na sem etu obi a sa akunya no so yede ewo ho say wo lawyer obetimi so ni lawyer kra na still no obetimi ayede afasa akunya so ama asem no so ayede etwa na yantwentwen sem so bebere and I think my tree is fine.
I think your tree is good. Thank you so much. All and right. Counsel, you are grateful.
Thank you.
You are grateful, and you are wonderful.
Thank you.
I think you are whetting my appetite for criminal law, but it won't happen. It won't happen. So thank you so much. Our time is up, and next week we'll be looking at legal documents. The most important legal documents you need to know about. So same time next week. Until then, please stay safe, and it's adieu from us.